Terms for the founder stock on issuance. As a fundamental tax matter, you need to grant equity at the fair market value on the date of purchase. Otherwise, you're going to have a tax consequence, because if you price the shares at below what they are actually worth, the IRS says that you have income equal to the spread between your purchase price and the fair market value on the date of purchase. The good news for founder stock is it is very unusual, let me put it that way, for the IRS to challenge a founder share price that's set in good faith. It would be one thing if you hadn't issued any shares and you already have $20 million a year of revenue and you decide to sell your 50% of the company for $1. The IRS is going to say, I don't think so. But that's not the normal circumstance. The normal circumstance is you're creating the company at an early stage, and you're usually doing it in the form of assignment of intellectual property. Usually founders will buy their shares for a little bit of cash and the intellectual property that they've created, and they get their shares in exchange for that IP. So even if the fair market value is, let's say it's $1 million, but for a startup, the only value is the IP. So if the company is worth $1 million, then the IP that was being assigned must have been worth $1 million. This piece gets very complicated, and we quickly get into the weeds on tax issues, and there are all sorts of corner cases that you can talk about. I promise you that piece you don't want to hear about, but if you have specific questions, I'm happy to ask that. Vesting. This is where we wind up spending most of the time when we're talking about founder shares. I mentioned earlier that setting up a company is like, it gets you the benefit of a prenup. This is where the real teeth of the prenup come into place. If somebody leaves, you don't want them to walk away with a bunch of equity that they didn't earn. If they do, you've lost a bunch of the value that the rest of the team has put into the company. So what we usually suggest is generally 4-year vesting, because that's what the investors will expect. And the conventional structure is 4-year vesting. For rank and file people, it's with a 1-year cliff, meaning that nothing vests for the first year. For founders, generally there's no cliff. The vesting just goes, say, straight line over a 4-year period. For founders, then the question is, how much extra credit do you get for what you've done prior to incorporation? What is the pre-incorporation vesting? What's the vesting commencement date? Credit for time served, it would say. There are different philosophies around this. My personal philosophy and recommendation is, again, keep it simple, be reasonable. Think of the vesting the way that your investors will think of it. Part of the reason for having vesting from the investor's perspective is that it is a retention tool. They want to be able to keep you around for at least a couple of years after they put their money in the bank, because they're investing in you, most importantly. If you're 50% invested up front, and then the Series A comes in and you wind up being 75% invested in the first year, there's a good chance that you've reached kind of the FU point, the point at which you're vested enough in your shares that you don't care anymore, and you're willing to leave because you've already got a ton of equity, and you can go off and do your next thing, join another startup, or do your own. So investors want to see as little as possible upfront vested, because they want you handcuffed in for as long as possible. There is a compromise there, and usually what I see being acceptable to investors is sort of 12 to 18 months of upfront vesting measured from the time of the Series A. They want to see typically at least 2 years of meaningful vesting still to happen from the time they put their money in. What can happen is that if you wait a while to do your Series A, or if you pre-vest too much, they'll just tell you to put the vesting back on. And it's not hard, it's just a contract. And it's you put a stock restriction agreement in place, or you amend your purchase agreement and say, boom, that 56% that you had vested, well, now it's 26%. So one of the arguments that people make was, well, if I put a lot of vesting up front, I have more leverage. Well, not really, because it's not hard. Just it's 45 minutes of lawyer time to draft the document. So you're going to have the negotiation on the substance, not the logistics, and so you don't really gain any leverage by doing it ahead of time. You're going to have this conversation anyway. And again, it's one more thing to negotiate with your investors. And so you want to, if you buy into the mantra of keeping it simple, this one is probably not one where you want to be so aggressive. There are other things that are more important in financing. Acceleration on change of control and acceleration on termination of employment. Change of control, there are two basic flavors of acceleration on change of control. There's single trigger and there's double trigger. Single trigger is acceleration, so the vesting lapses in full or in part when a company is acquired. The other is double trigger, which is after a company is acquired, trigger one, you're terminated or your life has been made so miserable that you quit, trigger two. Single trigger acceleration is very unusual. The investors hate it. As a practical matter, the reason they hate it is because that represents money that's going to have to come out of their pockets. Here's the reason why. When a buyer buys a company, they make a determination, company is worth $100 million. We're buying the company because of the team, and in particular the series, the technology team, but we know we're going to need the senior management, the founders, to stick around for a period of time. If the founders accelerate on a bunch of their shares, there's no incentive for them to stick around. What's in it for them to stick around for the 18 to 24 months that the buyer thinks they need to be there? So as a result, the buyer is going to say, I got to spend another $5 or $10 million worth of stock or cash to make sure that there's a retention tool in place so that the founders will stick around for the 18 months that I think I'm going to need them to be around to transition over to the buyer. The company is still only worth $100 million. They're not going to pay an extra $5 or $10 million. The company doesn't magically become worth $110 million because the founders are overvested. So that extra $10 million is going to come out of the pockets of the other stockholders, most importantly the investors, because the preferred would have gotten it first. So now you've essentially moved money from the preferred holders over to the founders. That's why investors hate it, because they know that's how that game gets played. So what you see is very little single trigger acceleration, typically none. And my recommendation is don't even ask for it, because it's not worth the conversation. And as a practical matter, when you're being acquired, you're probably not. You might be, but you're probably not going to be bought in the first year anyway. Probably, a slightly higher chance, but probably not even going to be bought in the second year. More likely to be bought in the third or fourth year. By that point, you're already more than 50% vested. So the benefit that you get from single trigger acceleration diminishes over time. Double trigger is different. Double trigger is a structure where you, the founder, say, look, I understand that I'm going to have to stick around, but I need to have the opportunity and the right to earn the shares. I don't want to be in a place where you buy my company and then you turn around and fire me and I don't get the chance to even earn the X percent of the equity that's still out there invested. So if you fire me without cause, if I run over a nun on the street, okay, fine, I get that you're gonna fire me and I lose my shares for that. But if I don't do that, I should get the chance to keep it. And if you decide you don't want me, then boom, I get the rest of my equity accelerated. Right of first refusal. Oh, sorry, I skipped severance. So acceleration on termination of employment without cause or resignation with good reason. Basically severance acceleration on your equity. very unusual for startups. Again, partly because of the fact that you are going to be upfront vested some. Partly it's just kind of the cultural norm that there's not much severance paid to founders. Maybe get a couple of months, but you're not going to get very much. Certainly not going to get full acceleration on a termination. I mean, you can set it. You know, one of the things about all of this is that at the formation, you can set it up, but it's pretty easy to change it. And so it's usually not worth the hassle. Right of first refusal. That is the right in favor of the company that if you want to sell your shares, the company gets the right to buy them at that same price. When it comes time to do a financing, there will also be a co-sale right of first refusal and co-sale right, where the investors get to buy your shares if you want to transfer. And if they don't want to buy their shares, they can sell their shares alongside at the same price. Lockup, that's an IPO. Your shares are restricted after the IPO. Purchase on certain events, divorce or bankruptcy. Divorce is where this often comes up. For founders of successful startups, their equity is by far their biggest asset. I mean, in a lot of cases, it's bigger even than their Bay Area house. And so, from a marital asset division standpoint, because I don't practice matrimonial law, occasionally it comes up here. They're going to fight over it. And so, if you're the company, you want to make sure that you have the ability to have those shares bought back and not sit in the hands of the disgruntled ex-spouse. Nasty things happen. They're big chunks of shares. You no longer have good information as to who controls it, how they're going to get voted. And frankly, if the disgruntled ex-spouse is really disgruntled, and I've seen this happen, they will actually affirmatively vote shares in such a way to hurt the company because it hurts their former spouse. Nasty stuff. That's why I don't do matrimonial law. Then I don't want to have an unlisted number and lock all my doors with bulletproof glass, which people do actually, by the way, have to do. Let's just go on to the next slide. Full time. Other classes of founder stock, and you guys have undoubtedly heard about both of these, and they're related but very different. Series FF, try that again. Series FF preferred. It's kind of the beast by many names. Starter stock, founder stock, although they're different. Founder stock is a bad term because it has different meanings. It's a way to get liquidity on a tax favorable basis in the hands of the founder. It's essentially common stock that has an option to convert it to preferred at the time of a financing. So if you have an investor who's willing to pay to buy the founders out for a portion of their shares, the shares just boom flip into whatever that series of preferred is. And it gives the opportunity to get liquidity for founders at preferred price. For a variety of reasons, mostly tax related, we generally limit it to 15% of the capitalization. And the biggest reason why is that you can't have vesting on these shares for tax reasons. You can't have founders stock vest. So if you want to do founders FF or starter stock, then we usually allocate the portion that would have been upfront vested anyway. And the purchase price has to be at a premium to common, because it's not just common, it's common with this right to convert. So that right to convert has a value. At the formation time, when the company isn't really worth anything, the spread is very small. As time goes on, and I told you lawyers are bad at math, but you start thinking about like the second derivative, as the value of the company goes up and the likely value of preferred stock goes up, the spread between the common and the preferred also increases, and so that spread increases over time. So if you buy the FF at the very initial point, you'll sell common at 0.00001, and you'll sell the FF at 0.0000125. Later on down the road, that the delta might be 10 cents for common, but $1.50 for the preferred, because it could convert into a Series B share that's worth $1.50 or $1.80. So it's something. Sorry, go ahead.
I didn't want to interrupt what you were going to finish saying, but if you can, when are these used? Are these used in angel seed rounds?
They tend to be used in B or later rounds, because they tend to be triggered when the company is hot. The company is successful enough that an investor wants to come in and is willing to pay the founders directly, and the existing investors are comfortable doing it in such a way that it makes sense to have the structure put in place.